Hey guys, my name is Shashwat and I'm a legal intern at LEXIS and Company. In this video, I'm going to talk about the recession of contracts. The word resigned means an express cancellation of a contract by one party. The recession must be communicated in the same manner as to offer. It is available where the consent is caused by fraud, misinterpretation, coercion, and undue influence. The right to rescind the contract in case of undue influence is given in Section 19A of the Indian Contract Act 1872. Then there are different modes of recession. First, recession by notice. Then setting aside by the contract, recession as a defense, and then comes the who can rescind a contract. The option of avoiding a contract is mentioned under Section 19 and 19A of the Indian Contract Act. Once affirmed by the person entitled to rescind the contract, it cannot be questioned by any third party. If one party acts fraudulently, he cannot be allowed as plaintiff or defendant or plead or reduce advice in support of his fraud. Where one party forms an agreement erroneously and the other party, knowing of the error, acts fraudulently, the latter cannot be allowed to take advantage of the error and enforce it. This, where both the parties have acted fraudulently, the courts will reduce to enforce the fraudulent transactions. Here, the plaintiff suit will be dismissed and the defendant who surpassed the fraud. This is known as the guilty party. And then comes what are the grounds for the rescission of a contract. The rescission may take place only after the contract has been fully established and thus no legal agreement has been entered into if a party is not aware of intent. Rescission is therefore neither necessary nor possible. Rescission is complete cancellation of the contract, which means all provisions will be terminated. There is one by mutual consent, which is the ground for the rescission of a contract. The process of rescinding a contract is that first it must be determined whether a contract can be rescinded. This can be done by reviewing the contract and its clauses to see if it contains rescission instructions. If there is no such clause in the contract, the person seeking rescission should contact an attorney or check the statutes in the state. If the court cannot be rescinded under the state or federal law, the person may attempt to negotiate a rescission with the other party. Any contract may be rescinded by mutual agreement even if it is not allowed by the contract itself. What are the problems which are faced in the contract formation? This is a very, very hugely asked question. In this, there is mistake, then fraud, then coercion, duress, and undue influence, which causes the contract formation to have some problems. Then, if a contract is valid until avoided, rescission may take place if one of the contracting parties lacks the ability to legally enter into a contract. For instance, when a party is under 18 years of age, intoxicated, mentally incapable, or ill, a party cannot enter into a contract. So this is it from my side. If you like this video, please share and do subscribe to the channel LEXIS and Company. Thank you all for